Welcome to Estate Planning Beyond the Binder.
Hello and welcome back to Estate Planning Beyond the Binder with Brian Chu. Brian is the managing partner at OC Wills and Trusts and has over 25 years of experience helping families across Orange County protect their loved ones and their legacies through thoughtful estate planning. My name is Kevin Rosenquist, and today we're talking about a very important topic for families who have a child or loved one with special needs: how to provide for them without accidentally disqualifying them from vital benefits. Brian, welcome back.
Thank you, Kevin. Thank you for having me on the show.
I think we've touched on this before, perhaps, but it's good to unpack this at a more so. So let's just start at the beginning. And could you tell us exactly what a special needs trust is and how it protects someone with disabilities?
Yeah, for us, I mean, the key thing is anytime you have a child or a potential heir that has special needs. In other words, they're likely, because they're unable to, due to disability, they're probably able to work or earn much of a living. They're probably going to receive certain government benefits, which here in California would be SSI, which is a Social Security benefit, and potentially Medi-Cal, which is something that's going to pay for their medical expense. In order to qualify for those benefits, not only they have to be disabled, but their assets have to be kept below a certain level. And in most cases, that level is $2,000. In other words, at the end of the month, a child can have more than, a person, an adult in this case, actually, cannot have more than $2,000 in their bank at the end of each month. If they have less than that, then they can potentially qualify for this SSI benefit, this monthly payment to help with their what's called supplemental needs, to pay for things like food and shelter. And so the issue is if, God forbid something happens, especially with parents of a special needs child, typically they're going to have money set aside for them to help take care of them moving forward. But if that money were just to go to them, and there's two issues. The first issue is they can't manage the money. So regardless, special needs trust or not, they need somebody to be in charge of the money, and the parents want somebody to be in charge of that money on behalf of that child. However, even if they have something like that, the fact that they receive the money, if they don't have a special needs provision or estate planning with a special needs provision, that money that child receives, or in this case, technically adult receives, would potentially make them ineligible for future benefits. And so we want to preserve both. We want to have somebody control the money on behalf of that child, and whatever money they do inherit, we want to keep that money so that the money can be used, but would not disqualify them from that benefit.
Okay, so leaving it directly to a special needs child or a special needs adult, so just one of their kids, could and most likely will negate those benefits, whereas using a special needs trust makes sure that you don't negate those benefits.
Correct. Yes,
Okay.
Because if they inherit $100,000, the only way to there are some different options, but at least initially, if that money's in their name, that would, as long as the money's in their name, they would no longer be eligible for those benefits.
So basically, you just whoever's in charge of it, make sure they get $1,999.99 per month. Is that kind of what you guys do?
I mean, that's assuming they have any money at all. Obviously,
Right.
There's, people with disability have varying levels of functionality. Some high functioning people are disabled. They may be able to work, fairly, minimum wage type jobs, and they might be able to control some level of money, which is fine. But again, at the end of the day, as long as the money's being spent and they get below $2,000, then that's fine. They'll stay eligible for the benefit. Now, there's obviously a fair number of potential special needs children who will never be able to manage their money. So,
Right.
It's never an issue that they're going to get money. It's just the money is going to be held in trust for them. Somebody of the parents' choosing will be in charge of that money, and the money can then be used for their needs, supplementing the benefits they're getting from the government.
Okay, and can anyone create a special needs trust? Do you need, is there an ideal time for a family to put one in place?
So when it comes to special needs trust, there's two situations. One planned for. In other words, somebody like parents are going to create, and in my case, what we do with our trust is we usually have the parents create an actual standard revocable trust, just like they would have done normally. But within the trust itself is a special needs provision. Okay, this is called a third-party special needs trust. In other words, the parents in their trust says upon their passing, whatever money is going to be set aside for that child will be held in that trust, and that trust moving forward will be treated as a special needs trust. In other words, there'll be special provisions in that trust to govern how the money is to be spent, and those provisions is what allows the money to be held in trust for them, but not count against the child. Okay, but the key there is that, and this is, I guess it doesn't matter who, is somebody is creating this provision in their own estate planning for their money that will be for the benefit of the special needs child. That's a third-party special needs trust. The other option is, and at least here in California, we have an option for a first-person special needs trust. In other words, unfortunately, when there's time where something is not planned for a special needs child, the most common two things is that child is going to receive a settlement, usually from some lawsuit. Usually, unfortunately, the reason why they're disabled, they're getting some money from that lawsuit. And as a result, because that money is the child's money, technically, because they're being awarded a settlement, that a first-person special needs trust can be created for that child. Either the child themselves, that person, or presumably at this point, adult themselves can create the trust if they have sufficient capacity, or somebody else can create it on their behalf. But technically, it is, since it's the child's money, it's considered a first-person special needs trust. But otherwise, like I said, if it's planning, done ahead of time, or the other circumstance was somebody, a child is a special needs adult is receiving an inheritance from somebody who didn't make any provisions for a special needs trust. Instead of them, again, receiving that inheritance directly, that money can be placed into a first-person special needs trust for that child, and thus they would be deemed to be with the money in the trust, they would still qualify for their government benefits.
Are there certain things it can be used for? I mean, like if the special needs person wants to make a purchase, let's say they want to buy a new couch and it costs a lot of money, or they want to buy a new TV, or they want to buy something more substantial than your everyday living expenses. Can they use it for that?
Of course. So the whole point of the trust is that, and here's the thing with the trust. First of all, the special needs trust, the point is that the person who's the beneficiary, the special needs child or adult, they will never have direct control of the money. They can request money, but they will never have direct control. Somebody else of the choosing of, will have control of that money. And that person's in charge, called the trustee. They can use the money for pretty much anything anything that would, assist the person or make their quality of life better. It could pay for travel. It could pay for a companion to travel with that person. Obviously, it could pay for furniture, pretty much anything that person can need. The only issue with the special needs trust, and that's actually the language written in the trust, is that whoever's in charge is going to try to preserve their benefits and not spend the money on things like technically food and shelter. Because if you do spend the money on food and shelter, there will be a partial reduction in their SSI benefit. You won't completely disqualify them, but there will be up to about $300, a dollar-for-dollar reduction if you spend it for food and shelter. But pretty much anything else you can spend on, and there won't be an issue.
Okay, so there's nothing that's going to, if you did pull out money to make a large purchase, that doesn't affect your benefits at all.
Correct. And the thing is, presumably the person, I mean, again, if it's a small item, the person, the special needs child can own it. But if the trust bought a house, the trust would own the house on behalf of the child, as an example.
Okay.
Buys a car, technically the trust would own it, not the beneficiary in this case. I did want to bring up one real quick thing. I talked about first person and third person special needs trust, and this is where the difference in planning does make a difference. Because you mentioned, when should you do this? Ideally, you want situations where it's going to be a third-party special needs trust, because the advantage of a third-party special needs trust, in other words, parents, example, set up in their own planning that the money will be held in a special needs trust for that child, which means it's their money. If that trust is set up, that trust can say when that child passes, or if the money is put into this trust and then it's not all used, that parent can then dictate where the money goes. In other words, presumably the other children potentially, or some other relative. The problem with first-person special needs trust is that when that's created by the, again, it's because it's already the child's money, because there was no provision for it. That money first, when that child passes, if that money's not used, it has to be offered back first in California, back to Medi-Cal. In other words, you have to say, did they use any Medi-Cal benefits? Which inevitably they did. And almost always they use, pretty significant benefits, in which case pretty much all the money is going to end up getting paid to Medi-Cal. Or if you're if you're not in California, it's using Medicaid, you're going to have to offer that money back. Whoever's in charge after that, the special needs child passes away, you have to offer the money first back to the medical insurance people first, and then whatever's left can go back to the heirs. But again, usually there's no money left. So that's why you want to do this planning in advance, even if it's other relatives that might be contributing to this special needs. That planning needs to be done in advance so that it is a third party special needs trust and not a first person, if at all possible.
What are some of the biggest mistakes that you see people make when they're looking to do this or when they set one of these up?
Finding the right people to be in charge. I don't know if it's a mistake as much as that's the hardest, in sense of, unlike being in the, a lot of times we have a trust, for, my kids are 15 and 17. If something happens to me, I have we have a sibling that'll be in charge of the money on behalf of my kids until they turn the age of, say, 25. Okay. And obviously that's because we trust the judgment of that person, over our kids. But at the same time, that person we put in charge, it's a finite amount of time. I mean, it's a maximum at this point, another 10 years, which, not complete, it's not a terribly long period of time. It's long, but not. Whereas a special needs trust, it's a lot more it's a little more complex than just managing money on behalf of a child or a young adult, where again, there is an end and they are going to presumably become more mature over the course of time. With special needs, a lot of times that's going to be a permanent thing. Right. It's potentially a lifetime thing.
Right.
And, and then there's, on top of the just spending money on behalf of somebody, there's the care issue on top of that. Okay. It's one thing, again, as kids, they're going to need less and less care. But for a special needs child, situation, their care may be increasing, or their need for someone to check in and things like that. So it's a lot harder to be a trustee on a special needs trust. And so you have to give a lot of, care and discussion, whoever, might do it, that they know what they would be in for if it actually came up to that. And so that's probably again, if there's a mistake, it's, beyond A, not doing it. I mean, that's initial, but B, is choosing the right persons to be in charge. Because, unlike, my kids, as they go, get older, as young adults, they have the ability to defend themselves to some extent. Right. They have an idea what's going on. I mean, that special needs child has, potentially no idea what's going on, no ability to defend themselves. So the decision of the trustee is even more critical at that point.
So maybe not a mistake, more of a pretty significant challenge.
Yes. Yeah. It's definitely, if mistakes are made, it's because they've chosen the wrong person. And a lot of times because they just assume a lot of things without actually discussing it. Yeah. And making sure the person's aware of what's actually involved.
Well, it's a big ask. Right. It's a pretty good sized ask to think.
It's a major burden, because again, it's just not, it's one thing to manage money. It's another thing to kind of manage a person on top of that.
Right. And potentially for their entire life.
Correct. I mean, and they don't have to solve that entire issue, because that person, whoever is in charge, can figure out who the long-term person might be. It might end up being a corporate trustee, or, there are some other options for that. So you don't necessarily have to figure out for the next 30, 40 years. But again, you've got to make sure whoever would do it knows what they're, what it involves.
And can help facilitate that handoff if and when that's necessary as well.
And that's the other part of it. Just like any of these, any trust, the logistics is the responsibility of the person creating the trust. Know where all the money's at, know what bills to pay. Obviously, when the special needs is a whole extra level of, logistical issues. Yeah. It's obviously, if that child, if they're completely disabled, obviously, something happens to parents. I mean, it's not just, we'll figure it out. I mean, that person needs help literally that moment. How does that,
it could be mentally too. So then you've got that aspect of things and to manage, and that's
and that person, may not be able to feed themselves. Right. They were completely dependent on the parent, and something happens to the parent, now that child's in real trouble. If something happened to me, my wife, my kids will figure it out for a few hours. 15 to 17, but special needs, they may not, so there's the logistical side of it as well is absolutely critical, beyond the, who's in charge of the money, which is the special needs part. But I always, go logistical part, especially in those situations, is really critical for the parents to figure that out ahead of time.
What about when other relatives, maybe grandparents, aunts, uncles, siblings, whatever, want to help as well? Is the best way for them to do it to add money to the trust? I mean, if they just give gifts, then that could also lead to the benefit issue, right?
So that's the question I usually ask the parents when they come in and want to do a special needs trust. If they're pretty much just expecting the money come from themselves, then we don't necessarily have to create a separate special needs trust. It can just be a provision. in their revocable trust, that trust converts to a special needs trust. However, if they're expecting money to come from grandparents, aunts, uncles, siblings, whatever, then they should go ahead and set up a standalone special needs trust now. That way, those people in their planning can then designate the money to come to that special needs trust.
Mm-hmm.
But yes, in that case, then you would create a separate special needs trust. And for the time being, that trust would just, it would be empty. It'd be, just empty at the moment, and it'd just be ready to receive funds if and when those people pass, and or if they were to contribute while they're alive, I guess they create the special needs trust at that point as well.
I have friends with some special needs kids, and it's a different life. It's hard. The things are a lot harder on them in a lot of cases. For anyone listening to this who knows they need to do this, but it just sounds so daunting to get started. You're just trying to manage your day to day, but you need to plan for the future. What's your advice for people who might be a bit intimidated, a bit overwhelmed by it?
Our job as attorneys is to make it easier. Okay. I mean, usually, again, the trust itself is, again, not the hard part. It's, again, going back, who's going to be in charge?
Yeah.
That's the hard part. Everything else is pretty much the same as we do, absent that situation for somebody that, wants to provide for their children and want to control how and when the money would go to our kids. As I always tell people, it's not much. We don't need to know a lot about the assets per se. We just need to know who do you love, who do you trust, and how much you trust them. It's names. You need to come up with names, and again, that's the hard part, is coming up with the names. But again, if you don't do something, it's you don't know who's going to be in charge, and B, you're going to have issues with government benefits and or the money, whatever money is set aside for them, because it will be automatic. If you don't have any planning and you have one child, they're getting everything. That's just the way it is. And now they'll be ineligible for their benefits, and they can do a special first person special needs trust, but now that money will likely never go beyond that child.
Right.
So I guess, at the end of the day, you want to get something done, and, as overwhelming as it might seem, I mean, again, the overwhelming part might be trying to find who's next, who's in charge. But if you can figure that out, you got to get it on paper. And
you got to get it taken care of. I mean, everybody obviously needs a plan, but it's even more, it seems like it's even more important in these cases.
And there are institutions out there, fiduciaries and or banks, that can take on that role.
Right.
You just need to talk to them, whether it be talking to with a private fiduciary, a private firm, or the banks. The banks have departments that have, deal with special needs. And, you want to find out whether that would be appropriate, an appropriate circumstance for the bank. Obviously you have to have enough money, but for someone like a bank to be the trustee on a special needs trust.
Yeah. All right. Well, definitely good stuff to hear. And thank you for listening to today's episode of Estate Planning Beyond the Binder. If you have a child or loved one with special needs, the right planning can give you peace of mind and protect their future without jeopardizing some very important benefits. To learn more, visit ocwillsandtrusts.com or call the office to schedule a consultation with Brian and his team. Don't forget to leave us a review, subscribe to the channel so you don't miss any further episodes. We've got lots of great stuff coming your way. Brian, always great chatting with you. Thanks so much for your time.
All right. Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.